Happy New Year 2026 to all of you, and welcome to the podcast of Ceven Law, based in Paris, France. On a monthly basis, we share and analyze legal topics relating to French law and international law, with a particular focus on corporate law, tax law, and immigration law. In this first episode, we will address a situation that often causes concern, and sometimes significant stress: on-site inspections at business premises in France, the legal procedures governing such inspections, and their potential impact on employers and employees. When an inspection takes place, the real question is not whether the situation is serious. The key issue is understanding who is carrying out the inspection, under which legal framework, and what remedies and safeguards are provided by law. First and foremost, it is important to emphasize a fundamental point: an inspection is not a sanction. An inspection is a procedure strictly governed by law, in particular by the Labor Code, the Social Security Code, the Code governing the entry and residence of foreign nationals, the Code of Criminal Procedure, and other applicable legal texts depending on the nature of the inspection. These rules define specific rights and obligations for all parties involved: public authorities, employers, and employees. No party may act outside this legal framework. Respect for jurisdiction, legal limits, and procedural steps is mandatory for everyone. What is an on-site inspection? An on-site inspection refers to a situation in which a public authority carries out checks directly at the place where professional activity is actually performed, in order to verify compliance with applicable legal requirements. The notion of business premises is not limited to a company's registered office. It may include a production site, a restaurant, a shop, commercial premises, a workshop, a construction site, offices, or a warehouse. More broadly, it refers to any location where employees work and where economic activity is effectively carried out. The decisive factor is not the size of the business, its legal form, or its sector of activity, but the reality of the activity carried out on site. Certain sectors may be subject to inspections more frequently, particularly where work is performed on site with a continuous human presence, and where material conditions allow for direct and immediate checks. This is often the case in the restaurant sector, retail, construction, or certain service activities. Which authorities may carry out inspections? Not all inspections carried out at business premises fall under the same authority or the same legal framework. They may include Social Security inspections carried out by URSSAF, relating to social contributions, payroll and declarations; labor inspections conducted by the Labor Inspectorate, relating to employment contracts, working time, wages, health and safety; administrative inspections carried out by local authorities and the OFII, relating to residence status and the right to work of employees; or interventions by law enforcement authorities, within a specific criminal framework, particularly where certain offenses are suspected. Each authority acts strictly within the scope of its own powers. Their presence on business premises does not automatically imply a breach or wrongdoing. General principles applicable to all on-site inspections. Regardless of the authority involved, certain fundamental principles always apply. These principles structure the procedure and protect all parties. In the context of an on-site inspection, inspectors must be clearly identified. Access to the premises must comply with legal requirements. Requests must be limited to documents and matters directly related to the purpose of the inspection. Focus on URSSAF inspections. Among the most common types of inspections, URSSAF inspections follow a highly standardized procedure, with clearly defined steps and deadlines. Understanding these steps is essential in order not to lose one's rights. Following the inspection, the procedure continues in writing: a letter of observations, to which the employer generally has 30 days to respond; a formal notice, marking the starting point of appeal procedures; a mandatory amicable appeal within a 2-month period; judicial proceedings before the social chamber of the judicial court, within a further 2-month period. Without a prior amicable appeal, any court action will be declared inadmissible. The role of employees during an inspection. Inspections do not concern employers alone. Employees may also be questioned, but their role is strictly defined by law. Employees may be asked to describe their actual duties, explain their working hours, describe their working conditions, and, where necessary, present residence permits and work authorizations. Working without a work permit. What does the law provide? Certain situations raise particular concern, especially those involving work permits. Here again, the legal framework is very clear. Employing a worker without a valid work permit constitutes illegal employment and gives rise to the employer's liability. However, this strengthened policy against illegal employment coexists with lawful mechanisms allowing for exceptional residence permits on professional grounds, particularly in sectors facing labor shortages. These mechanisms reflect the authority's consideration of certain economic and social realities, within a strict legal framework and on a case-by-case basis. For the employee concerned, wages remain payable, social security rights may be restored. In addition, any withdrawal of a residence permit must be based on a reasoned and lawful decision. Removal measures, such as an obligation to leave French territory, are subject to specific legal conditions. The authorities must assess personal and professional circumstances, including length of residence, integration, employment, and family life. Procedural safeguards and effective remedies must be respected. Administrative decisions fall under the jurisdiction of the administrative courts, according to specific procedures and deadlines. For employers, with respect to employers, the OFII may initiate an administrative and financial procedure independent of any criminal or social sanctions. A special contribution may be notified following a contradictory phase allowing the employer to submit observations. This decision may be challenged before the competent administrative court within 2 months of notification. When several authorities intervene simultaneously, when URSSAF, the Labor Inspectorate, the OFII, or law enforcement authorities intervene simultaneously at the same premises, the level of complexity increases. Each document or decision received corresponds to a specific authority, a specific deadline, a specific type of appeal, and a specific competent court. Analyzing each document individually is always the first essential step. Conclusion: on-site inspections at business premises are strictly regulated legal procedures. Understanding them, identifying the competent authority, and strictly complying with the rights and obligations of each party are essential conditions for effective protection. A few simple principles help approach these procedures calmly. Correctly identifying the inspecting authority, keeping written records of all exchanges, carefully monitoring response deadlines, and, where necessary, seeking legal assistance. Sanctions may only be imposed at a later stage, once a breach has been established. Any sanction must comply with due process, information, adversarial debate, reasoned decisions, and access to remedies. These topics will be explored in greater detail in future podcast episodes. This podcast is produced by Ceven Law. The audio voice for this podcast episode was generated using an artificial intelligence application. The firm practices in corporate law, tax law, and immigration law, and supports both employers and employees in the legal matters of the business world. Ceven Law also develops professional legal training activities, certified under the Qualiopi framework. Some training programs may be eligible for funding by professional bodies, in accordance with applicable regulations. This podcast is intended for informational and educational purposes only. It does not constitute personalized legal advice. For further general information, please visit our website, cevenlaw.com. Thank you for listening, and we look forward to welcoming you to the next episode.